friends, I'm Khushbu Maheshwal. Welcome to my YouTube channel Maheshwal STENO. Today I am going to give you a dictation at 100 words per minute. So get ready, 5 seconds to go. Even assuming that the arbitration process involved highly technical and complex issues, which was time consuming, even then it was open for the arbitrator or for the parties to approach the court for extension of time to conclude the arbitration proceeding, which was not done either by the arbitrator or by any of the parties. As correctly noted by High Court in its impugned judgment, there was no cogent reason for the delay in making and publishing the award by the arbitrator. He already had the relevant materials at his disposal and could base his findings on the observations made by the three arbitrators who were appointed prior to him. It has been correctly observed by the High Court that the arbitrator had become functus officio in the absence of extension of time beyond 30th of September 2005 to make and publish the award. After the said date, the arbitrator had no authority to continue with the arbitration proceedings. The learned counsel, appearing on behalf of the appellant, argued that in the absence of any statutory period prescribed under the Act for rendering an award, the direction of the court to conclude the arbitration proceedings within the time prescribed by it would not make an award passed beyond the time so prescribed null and void. He further argued that the High Court was wrong in not extending the time fixed by it in the order for early conclusion of the arbitration proceedings and terminating the mandate of the arbitrator when neither the Act nor the arbitration agreement prescribed any time for making and publishing the award. So far as this decision is concerned, we may keep it on record that this decision was rendered under the Arbitration Act of 1940 and not under the present Act with which we are only concerned. In view of our reasoning given hereinafter and in view of the facts involved in this case, we do not find any ground to rely on this decision of this court for the purpose of this case. We have carefully gone through para 8 of the decision relied on by the learned counsel for the appellants. We may not forget that we are concerned in this case with the Arbitration Act 1984 without going into the details of this decision. We may simply say that this decision cannot have any direct application. The principles laid down in the said decision cannot have any application in the present case, although the decision rendered in this case in the decision under the Arbitration and Conciliation Act 1996. Taking into consideration the arguments of the appellant, it is necessary to mention here that the court does not have any power to extend the time under the Act, unlike Section 28 of the 1940 Act, which had such a provision. The court has therefore been denuded of the power to enlarge time for making and publishing an award. It is true that apparently there is no provision under the Act for the court to fix a time limit for the conclusion of an arbitration proceeding, but the court can opt to do so in the exercise of its inherent power on the application of either party, where however the arbitration agreement provide the procedure for enlargement of time and the parties have taken recourse to it and consented to the enlargement of time by the arbitrator, the court cannot exercise its inherent power in extending the time fixed by the parties in the absence of the consent of either of them. The counsel for the appellant further contended that the High Court could not have terminated the mandate of the arbitrator. With reference to the contention made by the appellant that the arbitrator, having concluded the proceedings, could not be said to have failed to act so as to attract the provision of section 14 of the Act, which will call for termination of the arbitration proceedings. It is pertinent to mention here that the arbitrator had not concluded the proceedings as had been agreed to by the parties within the time fixed for doing so. It is an established statement that the said mandate of the arbitrator was terminated only because of the fact that the arbitrator, having failed to conclude its proceedings within time, did not warrant to be continued as an arbitrator in the absence of the consent of both the parties. It is clear that the arbitrator had extended the time provided to it without any concerned reason whatsoever, and thus his mandate was liable to be terminated. Subsection 1 further states that the mandate of an arbitrator shall also stand to be terminated if he withdraws or the parties agree to the termination. So friends, don't forget to like, share and subscribe my channel for more related videos and press the bell icon for instant notification. Thank you.